An employee walks into your office and tells you his or her financial problems. Then they ask you for a loan. What do? Do you make the loan or do you turn them down? My name is Nina, and I'm about to get in your business. I want to start out by saying that this video is meant to only highlight information on this topic. I've researched the pros and cons about loaning money to employees. It sounds okay in theory. The employee pulls you aside, states their problem, and asks for a loan. Further, they suggest that you, the business owner, can deduct the amount owed from the next paycheck. Sounds easy enough, right? Making a loan to one employee may lead to requests from other employees requesting loans. This can put your company in an awkward situation, saying yes to some and no to others. What if the employee doesn't pay on time? What if they request to negotiate payment terms? Or what if they need more money? What happens when the employee quits? I want to start out by saying that this video is meant to only highlight information on this topic. I've researched the pros and cons about loaning money to employees. It sounds okay in theory. The employee pulls you aside, states their problem, and asks for a loan. Further, they suggest that you, the business owner, can deduct the amount owed from the next paycheck. Sounds easy enough, right? Making a loan to one employee may lead to requests from other employees requesting loans. This can put your company in an awkward situation, saying yes to some and no to others. What if the employee doesn't pay on time? What if they request to negotiate payment terms? Or what if they need more money? What happens when the employee quits? If you don't want to loan an employee money for any reason at any time, I highly recommend adding this policy to your employee handbook. Should an employee ask you to loan him or her money, I would recite the company policy. The problem starts when you say yes to one employee while saying no to the other employee. This may lead to uncomfortable situations at work and possible litigation issues, as in a discrimination lawsuit, and other scenarios that may create a stressful working environment at your company. Different states have different laws related to this subject. Since I am based in Texas, I will focus on the laws here. Should you decide to loan an employee money, I recommend educating yourself on subject matters related to loaning money to employees. Some of those topics involve the Texas Payday Law or similar laws where you reside, the FSLA or the Fair Labor Standards Act, primary federal and wage hour laws, wage deduction guidelines within the Texas Workforce Commission, or whatever government entity monitors employment laws where you reside, and possible tax implications. In Texas, no matter what the employee owes your company, a deduction for a loan payment cannot take the employee's salary below the minimum wage for your area. Not only that, if the employee works overtime, you, the employer, cannot deduct the loan repayment using any of the overtime money earned. I advise any business owner who is considering loaning money to employees to review the rules and guidelines established by these two federal entities. Without getting away from the topic of this video, the Texas Payday Law, TPL, deals with, among other issues, how to avoid illegal deductions from employee wages. A deduction from an employee's paycheck to repay a loan must be authorized in writing by the employee in order to be valid under the TPL. It is up to the employer to document the loan in writing. There are a couple of documents recognized by the TPL that the employee would sign to validate this type of wage deduction. In addition, The reason for the loan must be lawful. An example of an unlawful payroll deduction is for a gambling debt. If gambling is illegal in your state and you bet an employee $100 for whatever, and you win, you cannot deduct the $100 from the employee's paycheck, even with all the documents signed for something which violates state and federal law. To charge interest or not to charge interest, that's something else to consider when loaning employees money. Interest charged to an employee's loan may be considered phantom income earned by your company. The FSLA and the Department of Labor, the DOL, are silent when it comes to deducting for these types of fees, and they might consider these fees as normal cost of doing business. I highly recommend consulting with your professional tax advisor for more information. When someone tells you to keep a secret, as sure as the day you were born, they are going to tell someone, and then here comes the snowball effect of everyone now knowing that your company is open for business with regard to loaning money. Guidelines may include maximum amounts, payment terms, interest rate charges, and types of loans. Loaning money in general is a touchy situation. If you choose to loan money to an employee, I strongly recommend that your company outlines formal rules and expectations surrounding that loan. Employers should never loan money or advance wages to an employee without treating the occasion like a bank would. That means securing the employee's written agreement on a separate loan or wage advance document listing all the particulars of the transaction, such as amount loaned or advanced, date of transaction, full name and social security number of the employee, the amount and frequency of repayment installment, and what happens to an unpaid balance remaining when the employee leaves the company. Some deductions are clear and straightforward, while others are complex and restricted. Find out what legal formalities are necessary in Texas or your state to make a valid promissory note, and include such language in the loan or wage advance agreement so that if the employee fails to satisfy the repayment obligations, the company will have the option of taking the ex-employee to civil court. Again, I highly recommend consulting with an employment law attorney who is familiar with both federal laws and the laws where you reside. Finally, consider this story from an actual Texas payday law wage claim that was filed in late 2006. The employer had allowed an employee paid time off for his wife's maternity medical leave and for her appointments, and in addition for spending time with their baby. The employer verbally agreed with the employee that the paid days off would be repaid one day at a time from future paychecks. But when the employee walked off the job soon after the child's birth, the employer deducted the full amount all at once from the final paycheck. Since the deduction agreement was not in writing, the employer lost the Texas payday law wage claim that the claimant filed. The claimant sent the following email to the employer. I know we agreed to you taking the 5 days you paid me for that I didn't work, one paycheck at a time, but I quit before you could take your money back. You are a dumb SH blank blank. The Texas Commission says without my signature, you can say we agreed to this verbally, but you lose since I didn't sign anything. I intentionally left your store open when I quit. Hope someone came in and stole everything in the store. Answer my call so I can tell you what a dumb SH blank blank you are. I now have a new trick with my next job. Take days off, promise to do makeup work, get paid, and then quit. Very sad. I hope you found the information in this video helpful. If so, please click that thumbs up button and share this video with other business owners. Did you ever loan an employee money? If so, what was the experience like? Did it have a good or bad ending? Let me know in the comments. Thanks for watching.